worked with Judge Herndon in the past. She will also be recusing herself from the vote on endorsement. My name is Stubbs. I'm an attorney in town, and I am moderating this debate. I'm not taking part in the questions. I'm simply here to keep time and to enforce the rules. The rules are as follows. Number one, there are to be no, if I could have your attention please, thank you. There are to be no attacks on other candidates. This is a panel interview, it is not a debate. And so we would appreciate it if in both the panel questions and in the answers, you treat it as such. If any candidate is referred to negatively, at my discretion, that candidate will have the opportunity to rebut whatever has been said, but we don't want to go there, so please, this is a panel interview and not a debate. We will start with 1.5 minute introductions by our candidates. Afterwards, each panelist will be given up to 30 seconds to provide a question, and then the candidates will have up to 1 minute to provide their answer, and there will be no follow-up questions by the panelists. And each question can either be directed individually or to the candidates as a whole. And so if we could start with Mr. Judge Herndon. I almost said the Honorable, but that's not proper here, right? I don't want to infer that the other person is not honorable. So Judge Herndon, if you could please start with your 1.5 minute introduction.
Okay. My name is Douglas Herndon. I came to... Thank you. Okay. My name is Douglas Herndon. I am originally from Texas. I went to Texas A&M University, graduated in 1986. I went to law school in Virginia at the Washington Lee University School of Law. Went back to Texas, took the bar, became licensed in Texas, but I had already accepted a job in Las Vegas, so I came out here in 1990. Began work as a law clerk in the district attorney's office. Thereafter, after passing the bar exam here, I became an attorney in the district attorney's office and spent the next 13 years as a criminal prosecutor, the last 8 years of which I ran what became known as the Special Victim Unit, dealing with the prosecution of crimes involving physical and sexual abuse and homicide, dealing with women and children. Thereafter, I was appointed to the bench by the late Governor Kenny Gwinn in February of 2005. I was retained in election in 2006, re-elected in 2008, and am seeking re-election again this year. Our court system, as you guys all know, I'm sure, is divided into a criminal and civil division and then a family court division. And within those three disciplines, we have 3 chief judges. I'm the chief judge over the criminal division of the 18th District Court system and sit on the court's executive committee as well. From a community standpoint, I spend most of my time with my family, being involved with my children's school, youth sports teams. I've been teaching at the Rape Crisis Center.
Okay, thank you
For
very
about
much.
18 years. Thank you very much.
And Mr. Michael Davidson.
Thank you. My name is Mike Davidson, and I've been here for about 35 years, been practicing for that whole period of time. First 20 years of my practice was private practice with my partner Stubbs. And when Stu decided that he was going to do his second term in the district attorney's office, he asked me to come over and help him to run the office, and I did that. I ran the entire civil division of the district attorney's office, representing all of the agencies of the county, all the elected and appointed officials. I ran the family division, where we collected over $60 million a year in child support, mostly for single moms, but for single parents as a whole. I went back to private practice after that, and then North Las Vegas asked me to come over, and I was the chief prosecutor there for 5.5 years. And I'm back in private practice once again, doing mostly complex civil litigation, but I'm a dinosaur. Back when we started, we all did criminal defense and a whole host of other work. Before anybody asks me where Patty is today, my wife, she's on a plane with her catcher's mitt headed to Wichita to catch our second grandbaby any day now. I have a wide experience in community service. I was on the Board of Governors for 2 terms. I was on the Supreme Court's Jury Improvement Commission. I served as one of the original, and for 10 years as a Supreme Court settlement conference judge. I served in juvenile court. I served as a small claims master.
Time, please. Thank you. Thank you for your introductions. We'll now start with our panel with Ms. Knight. If you could begin this question and answer.
Okay, I apologize. Mr. Davidson, I'm going to direct it towards you. Obviously, you're going against the judge right here. My question is, what made you decide to run against Judge Herndon with the Las Vegas Sun giving him such a higher approval rating? What are you going to bring to the court that's going to be different, that's actually going to exceed what he's already done this time around?
I give great honor to Judge Herndon for his service in the District Attorney's Office. That was great service to the community. There are differences between us, and if you would go to the websites, I think you'll see what those differences are. What I've said to people is that if you have spent your entire formative career as a hammer, everybody looks to you like they are a nail. What I bring to the table in this race is a much broader experience. I have actually represented individuals. I have defended the constitutional rights of innocent people. I've represented small business owners, large corporations. I have signed both the back and the front of paychecks. And I think that anybody who's ever stood in front of a judge understands that it is helpful to have a judge who's actually lived some life experience. When North Las Vegas had its troubles, my job was eliminated. I was a victim of that recession. As an attorney, as a litigant, I want a judge with that experience.
Thank you. I believe we should give Judge Herndon an opportunity to talk about his qualification as well. Is that okay? Thank you.
Is that okay?
Yeah, that's
Well, I'm about to be 50, so I think I have some life experience. And although I have worked in the district attorney's office and then went straight to becoming a judge, I don't think that means I don't have experience over a broad breadth of things, or with civil law or anything of that nature. The state's district courts are trial courts. What they need is judges who know how to conduct trials. I spent my entire career as an attorney, as a prosecutor, conducting jury trials. Jury trials are very specific animals, whether they're civil or criminal. There are some differences in rules of procedure, but nonetheless, it's a trial court. If you look through the Clark County Jury Commissioner's website, you realize that I've conducted more days in jury trial than any judge on the bench in the last 5 years. I run my courtroom very efficiently. I run my courtroom very effectively, and I think that's reflected in the judicial retention polls published by the Review Journal. I have the second highest retention rating of any judge who's been on the bench with a similar tenure as I. And everybody participates in this, not just prosecutors.
Please.
Thank you.
Thank you very much. Ms. Daywood.
This question is for Judge Herndon. What are the pros and cons of going to the bench as opposed to practicing law?
Very good question. For me personally, I like the idea of being solely responsible for all the decision making that comes with being a judge. Being a prosecutor as an attorney, in my mind, if you're doing that job right, you're doing both sides of that job. Your job as a prosecutor wasn't related to just making sure people got arrested, prosecuted, convicted, and put in jail. It was making sure the right person was arrested. It was making sure the right person gets prosecuted for the right crimes and gets convicted of the right crimes and receives a punishment, if any is necessary, that's proportionate to what they did. So you don't just look at it from a prosecution standpoint. You're trying to look at it to make sure that the people that are being prosecuted are appropriately there. You dismiss cases if necessary. So to me, becoming a judge was a natural offshoot from that. I enjoy being able to be, on both sides of that. I have prosecutors that get mad at me because I'll refuse to revoke somebody's probation once or twice or 3 times if I think they're worth keeping on probation. So it's not all a hammer and nail situation.
Thank you. Can we present that question to Mr. Davidson as well? Thank you.
Uniquely, I have done both of those things. I've spent 20 years in practice representing individuals, corporations, businesses, and I've also spent time on the bench hearing cases. And there are rewards to both of those positions. There's great reward in representing an individual who is accused of a crime that they're innocent of. And there's no greater feeling in the world than helping to set free somebody who's in that position. Being on the bench is an awesome responsibility. You have the obligation to do what's fair, to do what's right. And so I would say that it's hard to compare the two. For me, having spent as long as I have in private practice, I've made the decision that I want to devote the rest of my career to public service because I think that's where I can do the most good for the community that's been so good to me.
Thank you. Okay. Mr. Romani.
Sorry, again, the very boring question. Do you have a philosophy when it comes to motions to dismiss and motions to summary judgment? I know some judges think really everything should go to the jury and others don't.
We could start with Mr. Davidson on this question.
I'm going to give you a somewhat boring answer. As you are aware, the Supreme Court of the state of Nevada has recently entered rulings that define what the standard for summary judgment are. It is my philosophy, always has been my philosophy, and it's shared by everybody on the bench, I think, that cases should be heard on their merits. What the Supreme Court has said is that in the appropriate case, that it is a waste of judicial resources and time to allow a case to proceed if it is abundantly clear that the standards for for summary judgment, have been met. I don't want to bore everybody with what those are. But I think we will continue to be somewhat reluctant to terminate cases before they've had an opportunity to develop through the discovery process and to allow judges or juries to resolve cases on their merits.
Thank you. Mr. Herndon.
Well, my philosophy as it pertains to any motion is kind of the same philosophy that I bring in being a judge in general, which is you start, it's a very simple proposition. You start with the philosophy of you do the right thing. And that philosophy means you be prepared, you look at a motion on its merits, whether it's summary judgment or a motion to dismiss or whatever it may be, any other types of motions in limine. And you don't prejudge a result, you let the facts and the law lead you to where naturally it should go. The law is kind of a living and breathing thing to me, and at its core, it promotes fairness. So yes, I think Mike's right. Most judges on the bench would say, if your case is on their merits, that's what we try and do. On the other hand, on the bench, I think you'll find that most every judge would tell you that there are a lot of frivolous cases that get filed that cause a lot of consternation amongst people, the generation of fees and costs amongst attorneys while they're trying to defend those things, and it's our job as a gatekeeper to try and make sure we eliminate those things at the proper level so that you're not taking up jury trial time from cases that are more appropriate to go to jury trial.
Thanks. Ms. Alicia Green.
Hi. So I'm going to use instinct and experience interchangeably just for sake of simplicity. You've seen plenty of cases, Ms. Judge Herndon, and in the Special Victims Unit. And so I'm sure you could draw correlations between certain criminals, and beyond the facts that are presented to you, you can pretty much see beyond what's being told and what's being presented. So how do you handle that? Do you consider yourself a strong deliberator, or do you rely more on the experience that you have and draw those conclusions and judge accordingly?
Are you speaking kind of directly towards sentencing issues?
Yeah, you've been a prosecutor and,
Sure.
and you've seen plenty of cases. And I spoke to a prosecutor recently, and he said, in most child abuse cases, you usually see this, and that. Do you rely more heavily on what you have experienced through going for so many years to these cases, or are you a pretty strong deliberator, going back to what you said, our law is based on court that promotes fairness?
I think that everybody as a judge has to rely somewhat on their experience. It doesn't necessarily mean your legal experience, it's just your life experience in dealing with people. So I wouldn't say that I take a past experience as an attorney or prosecutor to bear on somebody's sentencing. Rather, you may take your past experience as an attorney or a prosecutor or a father to children, or a son to a mother, or an uncle, or somebody who has nieces and nephews, and you deal with all of that, how you've interacted with people to help judge somebody's personality, the sincerity with which they present themselves in sentencing. Sentencing is much more an artistic thing than it is a scientific thing. PMP, the Department of Parole and Probation, reduces everything to numbers. That's not of great value to me. You want to measure a man as he stands before you and figure out, do you think he can make it on probation? Does he deserve that shot regardless of what his prior criminal history may have been? Is the nature of a particular offense such that it deserves this kind of punishment absent any history or expression of remorse? But you have to combine all of that together.
Thank you, sir. Ms. Green, was there another question? Are you okay? Okay. Ms. Carroll? Oh, excuse me.
And Mr. Davidson could also answer the same question.
Could you repeat it, please, then?
My question was, when you're trying a case and you have the evidence presented to you, do you rely more on your evidence or do you rely more on experience?
I think it's a blend of the two. I have had the experience of sitting in very small rooms over at the jail when I represented people, and I still do, and had to take the measure of the people that I'm representing because I need to do that to be able to adequately represent them. But I've also sat on the death penalty committee at the district attorney's office. It was the district attorney and the two of us who were the chief deputies or the assistants, and had to make the very difficult decision very early in the case whether we thought that that was an appropriate case to seek the death penalty on. The most difficult decisions I've ever had to make. And so you always bring with you your prior experiences. You don't leave those behind, and anybody who suggests that upon taking the bench that somehow you become able to divorce yourself from what you've done for most of your life is probably being dishonest with himself or herself. But as a judge, you do have to make sure that you temper all of your life experiences with what you are seeing in front of you.
Thank you. Ms. Carroll?
Many times, courts have to work together, such as family court and district courts. How can you help foster cooperation between the courts, making sure that appropriate judges are notified about child abuse and stalking convictions so that those decisions are respected by other local courts and enforced? Judge Herndon.
Well, the criminal and civil division and then the family court division are kind of separate, although from an executive committee standpoint, we try and oversee administration to both sides of it. I have very little to do with the family court system, to be honest, other than having meetings with Judge Sanchez, as I said, on the executive committee. Judge Tagliati, as our chief judge, is primarily the one that has involvement with the family court system. But within any court system, one of the things that's been incredibly frustrating for many years, both as an attorney and now as a judge, is the inability of all the court systems and law enforcement agencies and whatnot to get a case management system that actually communicates between courts. I, for instance, can't access justice court to see what happened with a case, my own case that's in district court. I can't access family court to see what may be going on, for instance, and this was the same way as an attorney, maybe abuse neglect petition that's in family court that also has a criminal case component in district court. You can't access all those things, so you're left to try to phone people or whatnot. But that's the core of where it has to start.
Thank you.
Thank you.
Mr. Davidson?
Let me try to be a little diplomatic here. What you just heard is not quite true. There are circumstances in which there is a distinct overlap between family court and district court, particularly in the criminal court and district court. And I know of some circumstances in which a family court hearing master or judge has gone to a district court judge and asked for certain relief from certain orders that may have been entered in that criminal court to facilitate the reunification of a family, which is the job of the family court. And so there are circumstances in particular cases where there is a distinct overlap, and it is incumbent upon the judges who are hearing that case to communicate with each other and to determine what is in the best interest of the family, what serves the best interest of the community as a whole if there's some danger to the parties involved or to the greater community. And so my answer to that question is that, as with many other cases, the judges need to communicate with each other.
Thank you. Mr. Brooks?
Thank you, gentlemen, for showing up today on the panel and opening yourself up to the public for these questions. My question is for both of you to answer. We'll start with the judge, since you are the sitting judge right now, sir. In your courtroom, what do you do to identify defendants who are military veterans to be able to make sure that they can be qualified for a Veterans Court program if they do qualify for one? What steps do you ensure to make that that is not overlooked in the courtroom? And then Mr. Davidson, after he answers, what steps would you take to ensure that no veteran is overlooked in your courtroom? Thank you.
Well, for the most part, it all starts before court. I think what anybody would acknowledge if they spend any time during a law and motion calendar in a district court, they realize a lot of these things happen very, very quickly. You, for instance, in a criminal case or a criminal law and motion calendar, you may have 20 pages of cases, 20, 40 cases on calendar. You're going through things fairly quickly. So what is incumbent upon both the court as well as all the attorneys and any providers that become involved is what happens behind the scenes leading up to that day where you have 15 minutes in court. So the attorneys that I deal with know that if there's any question about somebody having military background, they're to look into that beforehand to ascertain it, and if it's not in the pre-sentence investigative report, then they're to raise that with the court. Generally, those things will always be in the pre-sentence investigative report. And then failing that, there's occasions where you're in court and you still have a question and you're just asking somebody to provide that information to you if they can. I kind of like to rely most primarily on somebody that's been able to document that beforehand, because you don't want to refer somebody if you don't have a basis in the case.
Thank you.
The truth is that every criminal case that comes into district court has been to a prior court. They come up through the justice court. And so there are many opportunities for the disclosure of veteran status. I, for one, am firmly of the belief that when we make decisions about people, we need to look at what they've done in their lifetimes. There's a difference between good people and bad or evil people. A lot of times we see good people, veterans, who through no fault of their own are put in desperate circumstances or have suffered some kind of emotional injury. And we need to distinguish between those classes of people when we have them before us. We need to do that through education. We as defense attorneys need to be able to identify for our clients to judges, this guy's a veteran, and so this may explain in part why his behavior was what it was. And so I think a lot of it is an educational process.
Sir. Thank you. And because of our current time constraints here, there's one more question. So, Ms. Dupree, did you have a question?
So, I would be interested in knowing your position on capital punishment.
Starting with me?
We can start with Judge Herndon, please.
Well, what I'll tell you is that as a judge, I mean, you're talking about an issue of a personal opinion versus what I should do in a particular case, because capital cases, I probably have 12 of them pending in front of me right now. So it's less important what my personal opinion is as to whether it's a viable form of punishment in this country, and more important that I follow the law. The law currently exists, allows for capital punishment. I will tell you, it's been pleasing to me that the aspect on how the district attorney's office pursues that has changed in recent years, and that there's been more freedom given, I think, to their deputies to go about resolving cases, even though they may have been filed as death penalty cases. But above everything else, I believe that the legislature enacts the law, and it's my job to follow that law, and it's not my job to advocate or be activist to change it in any way and say this is or isn't good, unless I'm asked to pass on the constitutionality of it. Which, with regard to death penalty litigation, there hasn't been any opportunities to do that, other than in a very limited fashion. That'll occur either at the Supreme Court or Circuit Court level.
Thank you. Mr. Davidson.
Bon après-midi, madame. Merci bien pour la question. I will tell you that I have wrestled with the death penalty question for many, many years, because it fell on my shoulders to have to decide whether we were going to seek the death penalty in cases. I will tell you that I have no moral or religious objection to the death penalty. It is the law in this state. I do have concerns about whether it is appropriately applied. And historically in this country, if you happen to be a black man accused of a crime against a white woman in the South, you were disproportionately treated. In many states in this country, we've seen death penalty cases set aside because subsequent evidence showed that the conviction was not warranted, and you don't get to take back the death penalty. And so we've always taken that responsibility very seriously when I was running the district attorney's office. It is the law of the land in this state. If I am a judge in this seat, I'll comply with the law, but I will always be careful in its application.
Thank you very much. I would like to thank the panel and the candidates. Thank you very much for being here. Mr. Davidson.